All right, we are, excuse me, are we back to our next video? We are going to turn to offer and acceptance. Let's bring up the PowerPoint. So traditional offer and acceptance is our topic. Let's remember where we are. Our plan is, right, as we've been saying, to look at offline contracting first and then use that to compare modern online contracting. We've worked our way through three of the doctrines we have to consider, right? Do you see them on the slide? And now we're to the doctrine of offer and acceptance, a critical doctrine for assessing online contracting and indeed for assessing offline consumer contracting. So contracts are formed by offer and acceptance. Everybody agrees on that. What we'd like to know is how does this happen in Stephen? In particular, what constitutes the offer in Stephen? Here are our facts in Stephen. To remind ourselves, he buys the life insurance policy in the airport at a vending machine. And this, what we want to know is, do these facts constitute an offer? This quoting from the case, the relevant facts. So we see number one, he bought the policy at a vending machine. Number two, right, here is what, number two, here's what he can see. He sees on the vending machine, these are the terms he sees, do not purchase more than a total of $62,500, principal sum, nor for travel other than scheduled air carriers, which we know turns out to be a critical term, but he doesn't see the definition, right? He's not even told that there is a technical definition, right? This policy covers a one-way trip only unless round trip ticket is purchased before departure. Three, below this printed statement, there's a box where you put in your name. Mr. Stephen puts in his name and address of the beneficiary, which in this case is his wife, his departure and destination, and how much insurance he wants, and the amount of the premium, and then he has a place for his signature. Right. The court says the evidence doesn't show whether he saw any more or there was any warning about what scheduled air carriers are. That's down here. And then after obtaining, then he mails the policy away after obtaining it, which means he doesn't have any additional time to read it. And the instructions were to mail the policy away to the beneficiary. So we'd like to know, is that an offer? And we'll answer in two steps. We'll first review traditional offer and acceptance doctrine, as it is indeed still taught in law school. I teach contracts every year to the first year students, and what we're going to review is how I teach offer and acceptance, which is the way everybody teaches it. That is the traditional doctrine. And then in the next video, we'll see how that applies to cases like Stephen, because you have to do some adjustments to apply the traditional doctrine to actual consumer contracting, offline and online. So here's traditional offer. Here's the definition. This is traditional offer and acceptance, and it is the definition used in modern online contracting. An offer is a manifestation of a willingness to enter a bargain, so made as to justify the offeree in thinking his or her assent will conclude the bargain. Now, the verbiage seems complicated. It's from the restatement, but in fact, you've understood this since you were 5 years old, no doubt earlier than that, right? Just imagine this scenario. The kindergarten bully comes up to you and says, I will not beat you up if you give me your lunch. What has the bully done? The bully's made a manifestation of a willingness to enter a bargain. Right? Bully's done that. No beatings in exchange for your lunch. Terms are announced right in front of you. And you even knew that the second part, you understood the second part at age 5, not in these words, right? But you knew from what the bully said that if you handed over your lunch, you had a deal. In other words, in the words of the restatement, you were justified in thinking that your assent, your handing over the lunch, would conclude the bargain, make the deal. right? And acceptance, which we won't worry too much about, is, as you see at the bottom of the slide, a manifestation of a willingness to enter the bargain on the terms proposed by the offer. There are interesting issues about acceptance in consumer contracting, but we'll concentrate on what is an offer. So let's take a traditional an offline contracting example that does not raise any of the problems that Stephen raises. This is a very straightforward example. In fact, the one I use to introduce offer and acceptance in the first year contracts at Chicago Cat. So Great Minneapolis Surplus Store advertises clothes for sale. Lefkowitz, a buyer, shows up and says, I accept. And the question in the case is there a contract? Which the answer is yes, if the advertisements are an offer. Here are the advertisements on 2 different Saturdays, right? One for brand new fur coats worth $100, first come, first served, $1 each. I'm sure that they're beautiful coats. Again, 2 scarves, a black lapin stole, lapin is French for rabbit, black rabbit stole, beautiful, worth $139.50, $1. First come, first serve. Lefkowitz showed up each morning on Saturday and accepted the offers, or tried to accept the offers. So what does he try to do? He tried to buy everything. He owns the store down the street, and every Saturday he'd show up to ruin their sale, right? He'd show up, wanted to buy everything, so when their actual customers came in, they'd have to say, sorry, already sold. So they refused to sell to him. Lefkowitz sues, claiming the advertisements are an offer. If he is right, then there is a contract which the store breached. So is he right? Well, we've got two parts, right? We got the manifestation part and the justified in thinking part. Let's go through each. What about the manifestation of a willingness to enter a bargain? Do we have that? To answer, just ask yourself, what are you supposed to think when you read the ads? Right? You're supposed to think, gee, they want to sell the clothes in the ad on these terms, right? So the ad's presented, manifested to you, and it indicates the willingness to enter a bargain. These clothes on these terms. So the manifestation of a willingness to enter a bargain part's easy. The ads are a manifestation of a willingness to enter a bargain. So what about justified in thinking that his or her assent will conclude the bargain? Again, ask what you're supposed to think when you read the ads. How are the ads supposed to work? I think we know how they're supposed to work. You're supposed to think, gee, if I go to the store and say, I'll buy the advertised item, I can get it, provided I get there before anybody else. So in our legal definition terms, you're justified in thinking your assent will conclude the bargain. Just like you were in the Bully case, hand over my lunch, we have a bargain. Go to the store, say I'll buy it, we have a bargain. So that's traditional offer and acceptance. Lefkowitz versus Minneapolis Great Surplus Stores and the Bully have the characteristic that the terms are all out in the open, presented to you, no question. Right, there's the manifestation. And the question then is, does this justify you in thinking your assent will conclude the bargain? Which is usually the question in these types of cases, because the manifestation is pretty clear. Now, Mr. Stevens not like that, right? Where are the terms? Where are the terms? Where is the manifestation? The question in Stevens not about, are you justified in thinking your assent will conclude the bargain? The question in Stevens is about the first step. Was there a manifestation of a willingness to enter a bargain at all? Because where's the presentation of the bargain? Where's the Bullies? No beatings in exchange for your lunch. Where's the store? Clothes in exchange for this amount of money. Where is that in this? Right. So that's our question. The question is about this, and that is the puzzle, both about offline consumer contracting. If you think about it, think about the offline consumer contracting you've done. You go to the store, you buy a product, right? My example I always use is the Polish hairdryer. wife and I was running a conference in Gdansk. My wife was with me. She says she doesn't like the hairdryer in the hotel. Okay, happens to be my second marriage. So I say, fine, we'll get a hairdryer. And we go out, go to the shop, indicate I want that hairdryer. Yeah, she's fine with, wife says, that's a good one, looks good. So although it's a great big, hard to travel with 220 volt Polish hairdryer, but only of use in Europe, but okay, we need it, right? So the clerk gets the hairdryer, gets a box, finds a piece of paper, puts a piece of paper in the bottom of the box, puts the hairdryer on top of the piece of paper, closes up the box, hand it to me, I pay, and we walk out. What was the piece of paper? That's what consumers call the warranty in the United States, the contract between me and the manufacturer of the hairdryer, in Polish, by the way. And my Polish is pretty minimal and certainly not up to reading legal Polish. So, but that is the manifestation of a willingness to enter a bargain. And we got the same problem that we do in Stephen. What manifestation? I mean, I didn't get to, even if it had been in English, I don't get to see it till after I bought the product. So I paid and walked away, and then I can open up and afterwards read the terms. So where was the manifestation of a willingness to enter a bargain? That is the problem we will take up in the next video. This video is to set up that problem. We'll take that up in the next video, where we look more closely at offer and acceptance in consumer contracting, and in particular at the contract in the box problem of offline consumer contracting. Then when we get to online contracting, we'll make an analogy with the contracts behind the hyperlink. Okay, no, like I said, I forgot to say it in the last video, but again, questions, let's use email. Got questions, email me. As I said, I will try to answer them first come, first serve, as fast as I can, as many as I can get to. So happy to have the emails. That gives us a little interaction. All right, we're good. Let me shut this down. And as I said, I will see you in the next video.